This is my group members. My name is Nur Farah Ashikin and our team Munir Musawir, Fayadah, Awanis dan Fakira Akilah. Our group will present the case of Gomati anak perempuan Balakrishnan versus LBP Logistics, which was brought before the Industrial Court of Malaysia under Section 20 Clause 3 of the Industrial Relations Act 1967. Gomati claimed that she was forced to resign due to hostile work environment, while the company argued that she resigned voluntarily through a WhatsApp message. The key issue was whether she resigned was truly volunteer or a case of constructive dismissal. After review the evidence, the court ruled in favor of LBP Logistics, stating that resignation was volunteer. This case highlights the importance of clear evidence in resignation dispute and need for employer to follow proper procedure to prevent legal conflict.
Assalamualaikum and hi madam, my name is Nurfaida Filza binti Ibrahim, matrix number 4233001261. So I will talk about case background first. Gomati Balakrishnan vs LPB Logistics SDN PhD. So this case was filed in the Industrial Court of Malaysia under Section 23 of the Industrial Relations Act 1967. Gomati claimed that she was unfairly dismissed by her employer LPB Logistics SDN PhD. The key issue is whether she was forced to resign or not. Secondly is claimant argument. Gomati employed as a customer service executive since 7/22, earning RM 2,700 per month. Next, took multiple medical leave due to fibroid condition but did not submit a full medical report. The last one is upon returning to work, she found that her responsibility had been resigned to another employee and making her feel sidelined, and then alleged that she was pressured into resigning involuntarily. Next is employer defense. LPB Logistics denied the allegation that the claimant was forced to resign, provide evidence of WhatsApp message from the claimant stating her intention to resign, like morning I want to meet you, I want to quit my job, thank you. Company director Miss Mindy Lim arranged a meeting on 7/2023 where the claimant reaffirmed her decision to resign. The claimant signed a resignation acceptance letter without protest. On 28/2023, she received and encashed her final salary check without objection. Next is industrial court finding. The court found no evidence of coercion or pressure from the employer. And then resigning work during medical leave was considered a normal business practice and not an act of unfair treatment. No proof of threat, intimidation or under pressure. The court referred to past cases as precedent. City Link Express SDN PhD versus Greenson Dauk, and then Bata versus Normadia Abu Suwad. Based on the evidence, the court ruled that the resignation was voluntary. Next is court decision. Case dismissed as the claimant failed to prove that she was forced to resign, and then no compensation was awarded as there was no unfair and dismissal. The last one is key takeaways from the case. Proper documentation is crucial in resignation dispute.
Three factors or issues. The first is resignation via WhatsApp message. The claimant, Gomati anak perempuan Balakrishnan, sent a WhatsApp message to her employer on June 2, 2023 stating, "Morning, I want to meet you. I want to quit my job, thank you." In view of this claimant message, the company's director, Miss Mindy Lim, called the claimant for a meeting on June 7, 2023 to clarify whether she was serious about resigning. During the meeting, the claimant confirmed her decision to resign and the company issued a formal acceptance of resignation letter on the same day. The claimant acknowledged and accepted the letter without protest. Her last working day was set for June 30, 2023, with June 29 being a public holiday and June 13 being used to offset her unutilized leave. Second is claim of forced resignation. Gomati Anak Perempuan Palakrishnan, the claimant, argued that her resignation was not voluntary, but rather was a result of the company's conduct, which amounted to constructive dismissal. She said that when she was on medical leave because of her fibroid condition, her company LBP Logistics Sendirian Berhad subtly encouraged her to quit by removing her files and job obligations. She said she felt unwelcome and undesirable at the workplace because tasks had already been transferred to another employee when she returned. Ms. Mindy Lim testified that the reassignment of tasks was a normal business practice whenever an employee went on leave, whether it was medical leave, annual leave, or unpaid leave. The purpose of this practice was to ensure the company operations continued smoothly without interruption. The company also argued that the claimant never officially protested the reassignment of work or expressed any dissatisfaction before resigning. There was no evidence that the company deliberately attempted to push her out or that she was prevented from performing her duties upon returning to work. Last, lack of medical disclosure and evidence. The claimant argued that her resignation was indirectly forced because of her medical condition, specifically fibroid, which caused her to take medical leave. She claimed that the company unfairly reassigned her files and work to other employees during her absence, leading her to feel sidelined and pressured to resign. However, during the hearing, the company's director, Ms. Mindy Lim, testified that the claimant never officially informed the company about her medical condition. The only documents the claimant submitted were standard medical certificate (MCs) for her leave days without any accompanying medical reports or explanation regarding her long-term health concerns. Since the claimant failed to prove that the company treated her unfairly or that her medical condition was a factor in her resignation, the court determined that the company had not acted wrongfully.
In this case, two important laws have applied: the Industrial Relations Act 1967 and Employer Act 1955. This law helped us to understand whether Gomati was truly forced to resign or her resignation was voluntary. Under Section 23 of the Industrial Relations Act 1967, if an employee claims they were forced to resign, they must prove that the employer action left them no choice. In this case, the court found no proof that the employer forced Gomati to quit. The next one, the Employment Act 1955, also apply here. Section 60F say that employee have the right to medical leave. The company allowed Gomati to take medical leave, but since she did not fully explain her condition, they resigned her work to keep operation running. In Section 14 of the same act, allow employer to dismiss worker for bad behavior, but in this case, the company did not fire Gomati or take action on her, showing that they were fair. In the end, the court decided that Gomati resigned on her own. This case teaches us that employees should communicate clearly with their employers, and if they claim unfair treatment, they need strong evidence.
Thank you, Asikin, for the explanation. Next, we explore the pros and cons of key workplace issue in this case. First, let's discuss the legal justification behind workplace decisions. The benefits include adherence to the Industrial Relations Act 1967, consistency with past cases, and preventing the misuse of resignation claims. However, it also has drawbacks. It may overlook workplace power dynamics by psychological pressure and discourage employees from challenging unfair treatment. Secondly, we examine employee rights and protection. Proper documentation strengthens legal compliance and transparency. However, concerns arise regarding employee vulnerability, lack of consideration for workplace pressure, and indirect caution which might discourage employee from filing complaints. Thirdly, we can examine employer-employee communication and workplace policy. Clear communication and adherence to workplace policy promote due process and reduce legal risk. for employers. But without strong dispute resolution mechanism, unresolved conflicts may create gaps in workplace practice and set a precedent for overlooking grievances. Next, we examine medical leave and workplace accommodation. A medical documentation is crucial for managing workloads and preventing misuse of leave. However, rigid policy might pressure employees with health issues and miss the opportunity for a more inclusive and empathetic workplace. Finally, we can examine precedent and future implications. Setting clear precedents provides a legal benchmark and reduces uncertainty in workplace resignations. But relying too much on documentary evidence may discourage employees from voicing concerns, leading to unfair outcomes in difficult work environment. In conclusion, while workplace policy and legal framework provide structure, they must balance fairness, employee rights, and ethical consideration. A well-rounded approach ensure a more supportive and just work environment for all. Next.
Okay, thank you to Munir. My name is Nurfakira Akila binti Paden. I will continue to explain about solution. I have 6 solutions. Number 1 is clear employment terms and policy. It can provide well-documented contract, leave policy, and workplace rule to ensure transparency. It's regularly update policy and conduct training to keep employer informed of their right and responsibility. Number 2 is improving communication. It's like require formal resignation letter and involve HR to document the process properly. It's conduct exit interview and encourage open decision to understand and address employer concern. Number 3 is employer support. It can stabilize a grievance system and can ensure fair leave approval to create a support workplace. It actually can offer medical accommodation and wellness program and counseling service for employee well-being. And number 4 is fair and inclusive workplace culture. It can promote diversity and inclusion through training policy and fair treatment. It can encourage mentorship, open communication, and anonymous feedback to improve workplace culture. Number 5 is legal compliance or training. It can training HR and manager on labor law, employer right, and proper resignation handling. It actually can maintain proper documentation of resignation, grievance, and leave to avoid legal issue. And the last but not least is workplace flexibility. It can offer flexible work arrangement and personal support to improve work-life balance, and can implement employer assistance program and prioritize well-being to increase retention. Okay, last but not least, I will explain about conclusion. Is between Komati Palakistan versus LPB Logistics in Berhad that having an issue whether the resignation was voluntary or a case of construction dismissal. In court decision, rule in flow of LPB Logistics as there was no strong evidence of forced resignation. In this case, we have a key lesson that I have learned. Number 1 is clear HR policy, that proper resignation and grievance handling procedure are crucial. Number 2 is effective communication. It's avoid miscommunication through proper documentation. And number 3 is employer well-being. Employer should address workplace issue fairly. In my recommendation for future, we support employer on medical leave to avoid claim of unfair treatment, follow legal procedure to handle resignation properly, and promote a positive work environment to reduce conflict. That's all from our group. Thank you.